All right, good morning, everyone. So why don't we start with Mr. Vogel, if you could do a roll call, please.
Certainly, Madam Chair. Ms. Dawson?
Present.
All right. Mr. Esme?
Present.
Ms. Evans?
Present.
Mr. Tatum? Mr. Tatum? Ms. Williamson?
Present.
All right, Madam Chair, for the 5 members are present, a quorum is present.
All right. So I do want to note that the January 24th meeting minutes have been posted to the task force website if anybody's had a chance to review them. If there are any corrections, any concerns, if anybody could just note that now. All right, hearing no concerns, I will note that they are approved. So just kind of, I don't believe it's on the agenda, but Mr. Vogel did let me know he has a little bit of an update on the research. So I thought that would be good to get that update first and then to go from there.
Thank you, Madam Chair. I just wanted to provide an update on what I've been doing in my research, which I think I can divide into three categories: answering questions from last meeting, continuing research on neighboring states, specifically North and South Dakota, and research on preponderance of evidence versus other evidentiary standards, sort of a systematic view of that across the country. So please feel free to interrupt me at any point with questions as well. And then actually, if you don't mind, Madam Chair, I'd like to, while I still got the floor, at the end of it, I'd like to highlight a change we've made to the task force website, which should enable public comment. Okay. So first questions that I think Mr. Esme had at the last meeting. So you asked about crimes of I forget how you phrased it, but essentially crimes of trust, fraud, that sort of thing in Wisconsin, in the Wisconsin statute. I looked the statute back over, and it looks like the Wisconsin statute, this is 50.065, just specifies crimes of violence against persons and criminal sexual conduct, but there aren't disqualifying crimes like fraud listed. And then in answer to your question about Iowa administrative codes, which just as a reminder, the Iowa statutes I looked at seem to give pretty broad discretion to their Department of Human Services to enact in their administrative codes what crimes or conduct what crimes they find disqualifying. I've poked into Iowa administrative codes, and it appears that those are likewise pretty broad in granting their Department of Human Services discretion. So, for example, Iowa Administrative Code Chapter 109 governs child care providers and licensure there. And there's a mandatory prohibition list, which is essentially the same as that in the relevant Iowa statute. A couple of crimes: domestic abuse, forcible felony, arson, and a mandatory five-year prohibition for anyone convicted of substance offenses. Is in that administrative code as well, but otherwise it doesn't really specify many specific crimes. Instead, it simply says that for other non-misdemeanor crimes, the department should review for safety. So it appears that Iowa likes to keep its options open. Moving on then to my examination of North and South Dakota. Those states I actually had a little bit of trouble with in my initial research, and it appears that's because their statutes empower them to also create administrative codes that are actually the actual meat of their prohibitions. Both states appear to have a permanency list, by which I mean they have a list of disqualifying crimes that are simply disqualifying with no discussion of appeal or set aside process. So I'm interpreting that as permanent. North Dakota, and I can send out the citations that I'm discussing after I'm finished presenting. Apologies. But North Dakota Century Code, Chapter 50, 11.302 is their administrative code for child foster care, and that lists very similar barrier crimes as permanent barriers to the Iowa list. So felony conviction for child abuse or neglect, domestic violence, a crime in which a child was a victim, including child pornography, and a crime involving violence, including rape, sexual assault, or murder, not including other physical assault or battery. There's also a 5-year bar in that administrative code for a crime involving violence not described above, a drug-related offense, or solicitation or conspiracy, etc., to commit the criminal conduct in the permanent list. Otherwise, however, the North Dakota Administrative Code appears to also give their relevant department a lot of leeway with other felonies to interpret risk of harm. I'll note this is for childcare specifically. I wasn't able to find an equivalent administrative code with a well-defined list of barrier crimes for other occupations. South Dakota likewise has administrative rules 67, 42, 1604. And again, I'll send out this citation right after I'm done here. But that likewise governs childcare, employment, and child fostering. And that likewise specifies some what I'm interpreting as permanent bars. There appears to be a lot of discretion in interpretation. So the language here is a crime that would indicate harmful behavior toward children, a crime of violence as defined elsewhere in South Dakota law, a sex crime pursuant to elsewhere in South Dakota law. Number one, though, seems to be harmful behavior towards children. That presumably involves interpretation. A felony conviction for domestic abuse, physical assault, or battery, and then any other felony in the past 5 years. So again, it's not as broadly enumerated a list as, for example, exists in Minnesota. Oh, Mr. Esme, yes.
I just am I understanding right that for both of the Dakotas, you were really only able to find sort of similar background check policies that relate to childcare and fostering, and we didn't see anything for chemical dependency or healthcare generally?
Yes, Mr. Esme, that's so. Yes to the first, not sure to the second. So okay. I don't want to definitively say that administrative codes for chemical dependency jobs, for example, don't exist. Simply that I haven't found them. I've been working with the legislative library, and they've been an enormous help. But they've best been able to dig up childcare codes, okay. And so that's sort of been my starting point for this sort of analysis.
So that's a place we're still working on, basically.
Exactly. Yeah,
awesome.
And I will.
Thank you.
Yep, and I will make a note to keep digging there. So yeah, basically as a summary with for North Dakota and South Dakota, those appear to have permanency and basically no possibility of appeal to get out of those, or to get a set aside for those sort of permanent disqualifications. I will note both of those are both of those states use conviction for their list of crimes, and that actually dovetails then with essentially telling you what I've already told you, but more officially that I've been working with the legislative library to examine codes across the nation, statutes across the nation for the evidentiary standards used. Basically, it's conviction everywhere. Like that's just that's just the simplest way to sum it up for statutes that are in some way equivalent to 245C. General conviction is the standard used. There's often presence on a child abuse or other registry, which I don't know what evidentiary standard that involves, but that's not the department that's doing the background check making that determination. Some states explicitly have adjudicated delinquent in in these crime lists, others don't. That's not a project I pursued systematically for lack of time, but that's something I could potentially look into if you're interested. And some states explicitly have a disqualification for pending charges, arrests, that sort of thing. But that's essentially an active case where there hasn't been an opportunity for a court to find guilt or non-guilt. But as a general rule, it's conviction that is the standard. Two states I'd like to highlight that are pretty much the major exceptions that I've found are New Mexico and Oklahoma, and those aren't much in the way of exceptions. So New Mexico Administrative Code, Title 8, Chapter 8, Part 3, which is essentially their administrative code that appears to do what 245C does, sorry, I'm losing my place here. It lists disqualifying convictions, and convictions is the word used that are a mandatory disqualification, and then and then it also gives their Bureau of Criminal, I think it's their criminal department. It gives their relevant department the right to find risk of harm for crimes or conduct outside of that list of specific convictions. So it specifies essentially evidentiary standards. I'm looking at 88314 here. Reliable disclosures by the applicant or a victim of abuse or neglect, domestic violence orders that allowed an applicant notice and opportunity to be heard and that prohibits or prohibited them from injuring, harassing, or contacting another, et cetera, et cetera. And the final language is any other evidence with similar indica of reliability. But again, that's discretion on the part of their department. It's not the department being required to disqualify an applicant. It's merely the department being empowered to use these lower evidentiary standards than a conviction to find an unreasonable risk of harm. Oklahoma is pretty similar. It disqualifies applicants who've been convicted of a certain list of crimes. And here I'm looking at Oklahoma Administrative Code, Section 340, 75, 715. But it also empowers the department at its discretion to find unacceptable risk of harm outside of that list of disqualifying convictions. And sorry, I'm looking for the specific language here. And this is specifically for child fostering, I should note. Apologies. Okay, here we go. Okay, yeah. So this allows their department to take notice of arrests or charges outside of the list of convictions. Again, giving them the discretion to find risk of harm, not requiring them to disallow or to disqualify an applicant. So, those are the major exceptions that have stood out in this search in looking for evidentiary standards. As a general rule, you find conviction as the word in these statutes, with again, potentially being on a registry, something like that. So it appears that Minnesota's system of a distinctly lower evidentiary standard than beyond a reasonable doubt, where our department is the finder of fact, that appears to be a very strange system nationally.
And Will, if I could just really quickly, it also sounds
Absolutely.
like you're not finding other states that have our 15-year, 10-year, at least from what I was hearing, it sounds like there's more of a permanent and then a 5-year.
That appears to be the case with these neighboring states. Yes, Madam Chair. I wouldn't feel comfortable saying that's like I'm very comfortable, just blithely saying that conviction is the standard throughout the country. I wouldn't be comfortable in saying that throughout the country, but that does seem like a good observation for our neighbors. Ms. Williamson?
Thank you so much. Thank you, Chair Dawson, and Mr. Vogel for this presentation. So I just wanted to comment in regards to you shared some information, your research in regards to adjudication. And I'm just wondering, if we could dig a little deeper into that, because I think that speaks to the uniqueness of how Minnesota is applying its accountability or applying its criteria. It is off of the basis of adjudication. So I think that would behoove us to look deeper into that.
And I certainly can do so if the group would like me to. And Madam Chair, Mr. Esme's hand is up. Sorry, I'm sort of fielding these questions.
Nope, totally get it. Yeah, Mr. Esme, if you want to go.
Just a quick clarifying, because I might have just missed it, but when you were talking about the 2 outlier states, were those again mostly childcare statutes that you were looking at?
It appeared to be, so both states appear to be doing this in their administrative code. It was a childcare administrative code in the case of Oklahoma. It appeared to be a general human services workforce administrative code in the case of New Mexico.
Okay, thank you for clarifying.
Yep.
And
all right.
I don't know and I don't know how much you've looked, just this struck me when we heard Joanna Woolman at the last large meeting, how she, I think the new laws are to try to bring us closer just with the Adam Walsh Act. Could you, if you've compared it all to that, are any states following that more closely? Because I got the sense she seemed to be indicating that Minnesota, at least for foster care, was really much broader than Adam Walsh, and we were trying to bring it in. So I'm just wondering, kind of based on some of this, if you compared any of it to the Adam Walsh, and if that maybe is the starting point for other states, if you can tell.
Madam Chair, that's an excellent question. The short answer is I haven't completed that comparison yet, but that definitely is an action. That is an agenda item. For example, I've been wondering if that Iowa, if the list of specific crimes in the Iowa statute is essentially Adam Walsh compliance.
Yeah, and I just a moment, if you don't mind, Mr. Esme, because that's just something I was trying to look at the Adam Walsh Act, and it's of course very long and there's quite a bit to it. So to wade through it quickly is not easy. So, but I was curious about that. So yeah.
I'll definitely bump that up to the top of my research list.
And because even that one looked like they talked more about convictions, juvenile adjudications only in certain circumstances. So I'd be curious. Okay, sorry, Mr. Esme.
I just wanted to, I think I'm maybe making the same point that you were just making. First of all, I agree the Adam Walsh Act is very, very federal code. But I guess what I was wondering, seeing that Will has found a number of states that seem to have pretty clear childcare rules, but less clear, at least we haven't found them yet, rules for the other areas that 245C impacts. I wonder how much of that is driven by those states, efforts to comply with federal requirements that specifically relate to childcare. So yeah, I guess that's sort of the same thought, but I guess for our point of view, like, it is worth considering that if they have a much sort of narrow like category of, employment opportunities that they're regulating, that might impact, what is appropriate for a remedy, and that we need to keep in mind that our system is so broad and impacts so many different people that I think that weighs towards having a more accessible remedy.
And I think I'll jump in now, if you don't mind, Madam Chair, and do the other completely different thing, just so I don't interrupt discussion, because it sort of sounds like discussion starting. I just want to advertise that based on the task force's request that we enable a means for public comment, that we now have one up on the task force website. So this, I'm on the task force website homepage right now. We have these other tabs up here, meetings, which takes us to the task force meetings and the subcommittee meetings. But if we scroll down from this task force homepage, we've now put up this button here that and some language soliciting public comment. It's essentially language written to be as broad as possible, just asking for the experiences of anyone who's been connected to the background study process. So the intent there is to solicit people who've had background studies, employers, that sort of thing. The web form that this creates is by default anonymous submissions, but we have included some language that if members of the public are interested in sharing their contact information, or potentially in testifying or otherwise sharing their story in these meetings, to share their contact information so we can get in touch with them. So I of course will be sharing this with the whole task force meeting on Friday as well, but I just wanted to use this opportunity to essentially advertise this. If anyone, for example, in your interpersonal networks is interested in sharing their stories, we now have this means for them to do so. So just so you're aware.
No, I think that's super helpful. I have a former client who was interested in sharing, but he was a juvenile and his record is expunged. So I think he was hoping to remain a little bit more anonymous.
Gotcha. Well, anonymity is definitely an option. In fact, it's the default option.
Perfect. Okay, so kind of just moving on from there, as we had kind of ended last time, we really wanted to start talking about sort of the topics that we really want to try to make sure we cover. And I know we had talked about having a little bit more of an in-depth conversation, especially, I know last time we had someone from DHS present, and I saw we had somebody today too. Is it Ms. Kissane? Am I saying it right?
Yes, Madam Chair, Emily Kissane. You
Hi.
said it perfectly correctly, which is a rarity.
Perfect. Well, I always want to double check, and with my name that gets screwed up as often as it does, I always check first. And I just don't know how much, if you, Ms. Kane, is saying we're just planning to be present to answer questions, if you had specific information you wanted to share, or if you're just here to observe, I want to just make sure we're not forgetting that you are here too.
Thank you. And just for everyone, I'm Emily Kissane, and I'm a policy analyst with the Background Studies Division at DHS. And I'm here to answer questions as I can, to take questions back and get them answered for you, to be a resource best I can. So
Thank you
nothing
so much.
specific to present, but just here.
Perfect. I just wanted to, in case you came with a fancy PowerPoint, I didn't want to keep that out if you had something planned.
I'm sorry, I don't.
No, that's totally fine. All right, perfect. Well, I'm sure if anybody, I guess, has anything initially, we can, of course, launch right into that. But I think just sort of continuing our discussion, I guess, and I don't know what people think, but I kind of feel like over our last several meetings, at least this subcommittee has definitely identified some pretty big, I think, topics that seem to kind of themes that keep coming up. So, for example, the POE standard, of course, seems to keep coming up. The permanency list and really what that means, and the breakdown of all the various disqualifications, as well as I guess I would identify maybe a third one of really the actual appeal process and that accountability and the timeline. And welcome, Mr. Tatum. And just kind of that actual process and how that works and where that goes from there. So I don't know. I mean, I'm just kind of starting the conversation here. So, but that seemed to me to kind of be, at least in this subcommittee, I know the other one is really focused a lot in on the juvenile one. So I don't know if it makes sense for us to focus too much of our time there. It is important, but it's for sure being addressed. So I guess just kind of starting it right there. What people think.
I just want to say I apologize for being late. I was running a little bit. I got a little promotion at work, so trying to figure that out and hire people. Right, well, I got to hire a couple more people, and it's new to me, so it's just trying to figure it out, make sure I do everything right, and yeah. But I'm happy to be here. Sorry, guys.
You're totally fine. It's Monday. So just kind of starting with that. Any thoughts, anybody?
I guess I would say those are sort of the big buckets that I had to kind of with maybe lots of sort of smaller concerns in particular that sort of fit into the like appeals process bucket. So, things like, how quickly is it turned around? How easy is it for applicants to get DHS the information that they need to get them in a way that actually gives them a chance to maybe persuade somebody, those types of things.
Mm-hmm. Yeah, and I think that makes sense because I know one thing that's come up a number of times is, of course, for example, the 30-day turnaround time where you have to have all your documents, and that's just not always easy to have. So no, I think that makes sense. And I don't know if we are to where people are starting to feel like we have enough information to kind of start thinking about what do we really want to recommend. Just looking at the POE one, I mean, we're definitely hearing, I think the research is really supporting that for the most part, with a few exceptions, it seems to be conviction that's the requirement and not just the POE standard. And so I'm just opening the floor. I'm just curious what people are thinking and how we want to start formulating that. So go ahead, Mr. Esme.
Well, I think I sort of generally lean in favor of eliminating the preponderance of the evidence standard, or at the very least, like very, very much narrowing when it comes into play. One thing that I thought was really interesting from Ms. Woman's presentation last time, though, is that, the department has actually taken steps in recent years to sort of reduce the number of cases that come in under that review standard. So I'm sort of excited, I guess, by the possibility that there may be some kind of agreement there. One thing that I'm really interested in, though, and maybe this is something that we could ask the data people, but like how many less cases ended up getting disqualifications when they sort of narrowed the pool of cases that get that review. And then I guess I would add that while I think it's awesome that the department has already taken steps in that direction, one of the things that was apparent is that those sort of discretionary decisions can change over time and have changed over time. So I really think that isn't a reason that we shouldn't recommend that the statute be updated to reflect the policy that is most appropriate.
Well, and I think I would agree with that, especially just as somebody who tries to advise people of, well, you haven't been charged, so theoretically this shouldn't show up, but 5 years it could change. Mr. Tatum.
Oh,
Mr. Esme, yeah, I was thinking of some thoughts when you were just talking about it. I was thinking more of like more like personable, what that looks like. I'm not sure, like, because it's not like user friendly, like far as what individuals trying to fill out the paperwork, not having knowledge about that might be new for them. So I think it'll be I'm thinking more user friendly, far as what having some kind of contact with somebody, instead of somebody sending you a paper, you don't even know who's telling you like, we don't want to see you no more. And I kind of got like, I don't know, it was kind of personal for me, because I'm in the situation. So just by hearing the presentation last week, it kind of made me feel like, how can I say, stigmatized, just by certain wording. That's just me. Others might not see it that way. And it's like words like the integrity of the program. And so because I have a criminal record, is that saying I'm tarnishing your reputation of your program, or what is it really? Like I said, it's just me, my thoughts and how I took it, and just going along with the ropes, because this is all just paperwork, and not individualized. So, like that's how it was done for me. I was given a set aside work on a supervision the first time, talk to nobody. I'm like, okay, what does that mean? What am I supposed to do with that? Actually, what does that look like? And talk to Bayla and Jonathan Lofgren and just other people, just try to get some direction. Like, yeah, you're good. You just got to finish and work under, and then other later and changes, happen. And, oh no, we're just saying this now, so it's not really personable. You're not sitting down with nobody, getting direction. No rehabilitation type of strategy or some way to make it so that an individual could possibly still have hope and try to, somewhere in that direction or going in that direction. No open doors nowhere. And that's just like you just, if you ask me, it's just setting it up right back for criminalization. Going back, failures, thoughts. It took me a lot. I'm glad I had the motivation I had. Because it was easy to resort back to instinctive drift. Like just this is I'm normal. I know I could. I might not. Well, actually, it wouldn't have worked for me because I have too much information now. So, but it's easy to go back that way though. So I just think more personable. What that looks like, I really don't know right now. But just some kind of way where you can just reach somebody and, talk with somebody. I know they just said, this is what it says. And we're just going off the evidence, like you said, Esme, like what was that word you used again? It's not the evidence, but it's in the paperwork. What was that? The factors in the evidence. What did you call it? I can't even think of the word of it yet. Well, anyway,
I'm not sure.
Yeah, pondering of evidence.
Oh, the preponderance of the evidence. Right.
Evidence.
Yeah.
I'm like, everybody keeps saying, I'm like, I'm kind of figured out just
The POE standard.
Yeah, and I think that should be more like, like you said, somewhat go away from it, or like the big word going around now, reformed or whatever, something. Yeah, but more personable. That's where I come off at, and like I said, yeah.
Well, and I wonder if the solution to some of that is, if we're looking at potentially recommending going away from the POE standard, perhaps for sure reducing, and I pulled back up my notes from when Joanna Woolman talked, and it was just interesting because she specifically talked about how there were really only 7 to 10 crimes that were really a permanent bar. And then it was a permanent bar, and it looks like a 5-year bar. How much that would even perhaps help reduce a lot of what you've gone through, Mr. Tatum, and other people similarly situated, because we're looking at a much smaller list that in theory would then be much more focused on the actual risk of harm to the people that are being served, and not just a blanket list just to have a list. And so I'm just kind of wondering, and then, especially if we're looking at being able to have people feel like they're heard, if we do want to look at, like, I think some states, I think Iowa, if I remember correctly, or even if there is a permanent bar, there can still be some sort of a right to be heard. And so, people don't feel like they're permanently on the list. So I'm just sort of talking and throwing things out there.
Madam Chair, if I may.
Yeah.
Just in talking about the appeals process, I know in the data subcommittee, we had discussed about, like, with employers, as far as when they're providing that thank you, no thank you letter, that there could be more clarity in regards to the appeal process. So that's something we can consider as part of our remedies.
Okay. No, and I think that's helpful. And I do think the appeal process is, those of us who deal with it, we know we know how it's supposed to work, but your average person doesn't. So I think making that as user-friendly as possible for sure makes sense.
Yeah, and I would just add to that one of the things that's confused me as like even a practitioner is that like there actually are different appeals routes depending on the type of background study, and some go to administrative law judges and others go to DHS judges. And I think actually we pin this down, but it may actually be the case that even the standard of review then for that judge changes, and some are able to do like a full evidentiary hearing that sort of starts from scratch, and the judge gets to make their own discretionary decision about whether the act that amounts to the disqualification happened or not, whereas others are limited to just looking at whether or not the agency abused its discretion and making that own own determination. So that's just an area to highlight. I might Cassie and I might work on that between now and the next meeting to see if we can pin down those areas of sort of discord in the statute. And then it would be my recommendation that, you know, absent some compelling reason for them to be treated differently that I'm not thinking of, that everything gets the same appeal right for purpose of clarity.
That, Madam Chair, if I may, that Mr. Esme, that is actually a fantastic point to raise, because yes, depending on the appellate, some of them are just looking to see if there was some error in the process, right? So being able to have that clarification would be very, very, very significant. So I just wanted to praise that idea.
Well, and I think it definitely can be supported, you know, also from a standpoint of really just having that clarity, because it just gets so confusing. And so rather than keep it confusing, make it the same. I like it. What about anybody, Mr. Tatum?
Yeah, I just wanted to like, this is the remedies. I was wondering what, like you said, we got to have it in a certain amount of time. We got what, like 3-4 weeks or something. We got to have something put together, or what?
Yeah, I believe so.
Okay, so what is the list of what we have together, and what do we need to start looking at to be adding, or what are we looking at to recommending? Yeah.
Yeah, and I think, you know, Mr. Vogel, since I know you're kind of working on some of that, I want to make sure we get you what you need and get it to you, of course, with enough time. So do you need us to be voting like soon on what we want to be recommending? Like, what do you need from us?
Madam Chair, so I definitely need whatever recommendations that you'd like to make. I think the next meeting of the 21st is still fine. If, like, obviously if you make recommendations today, that's also fine. As for a formal, sorry, I'm trying to think through procedure. It's I think more a question of what what the task force as a whole would want to recommend. So I guess in turn it'd be a question of what specifically this subcommittee would want to recommend to the task force to recommend, if that makes sense.
And could I just clarify, for this first report, am I right that what we want to be doing is identifying areas that we think are a problem? And we don't like, and then for next year's report, it will be our actual recommendations about what the policy changes should be.
Mr. Esme, Madam Chair, that's certainly an option for the report. The statutory language that set up the task force is very vague on this report. It simply needs to happen. So it could be anything from simply saying that the task force has begun its work and needs more time to formulate suggestions, to suggesting specific recommendations, to suggesting specific statutory language, whatever, you know, wherever in that spectrum you want that to fall.
Madam Chair, if I may, to Mr. Tatum's point, have there been any recommendations that Remedies has already started on? And I just speak this in regards because I've missed a few of them. So I'm just curious as to if there's any that we've we've given to Mr. Vogel as of this point.
No, and I think that's part of what we wanted to discuss today, was to start narrowing that down, which was why I started open the conversation with at least how I was seeing sort of the three main buckets that I think we're seeing that seem to really kind of keep coming up and keep furthering our conversation. So at least that's, to me, the starting point, but nothing's been voted on. Ms. Evans?
We left the language wide open very intentionally, so that if we got something done and had recommendations to make for this legislative session, that was an option. So it really could go either way. If we have something that we think we could get bill language in for this session, we can make recommendations for this first report. Or we can just say, here's the data we've pulled, this is what we see, and then here's what you can kind of expect from us in the final report at the end of our time.
Well, and I,
Madam Chair, that just
Yeah.
raises a question for me. So Vice Chair, is that to say that we can look to, is it like a both and, that we could give suggestions or have Bill introduce a bill at this regular session, and then again also in December be prepared for 2023 session?
We intentionally left the language in the bill vague for that reason, so that we could do both. Yep. I don't, I don't know that we have enough information though to, yeah. I mean, I'll leave that up to the chairs though of the subcommittees to decide.
no, and I do think I would agree. I don't know that we're at the formal, what's the actual language that we all would recommend. To me, I guess, and I don't know how other people feel, I think that this state comparison has been extremely helpful. I do think sort of one more, especially with the Adam Walsh, would be helpful, just to really have that. And also knowing that that apparently had some success going through the legislature for the modifications that Joanna Woolman talked about. I think that that in and of itself sounds promising for us too. But I do think, based on our conversations, that I think we are, I mean, unless anybody disagrees, I mean, I think we're all pretty set on or agree that at least we have these three main buckets that are areas of concern that seem to sort of keep coming up as the primary ones. And I think we started off with a lot more, and I think we've just narrowed based on all of our conversations. So I don't know if anybody disagrees with that.
I was thinking, like with the process of it right now, I'm like you saying, for the last one that got put in last time, you saying add some of that information. I just want to make sure I'm hearing that correctly, or the way they were going, like on the last one we were talking about, like when they put the last bill in, you know, I don't understand it all the way correctly, but I just wanted to know what like some of that language would be that will be in there, and how would this be beneficial for some kind of rehabilitation, some kind of direction going for like making open-mindedness, you know, because of like, if you see it though, it's just like Minnesota's a state of like, is a humanistic state, treatment, big rebuild, start over, you know, we will help you. You know, Minnesota, that's how they are. They give you chances. They will work with you like that. And so I just think it needs to be more aggressive of like rehabilitation somewhere in there, you know, because they will accept that. You know, even with the senator was like, we ain't looking at the ripple effect, how these people are being affected. Just seeing them, hearing, saying, you know, just things like that. And just that's open-mindedness, you know, and open for language, for, you know, for discussion, for making it a little bit easier for others, just because you're afraid of what somebody might do shit. You know, it just doesn't make any sense to me. Then, like I said, I don't know this process. I don't know how, you know, I don't know what they will accept or what they're open to. And, you know, this is my first time ever doing this. So I'm just voicing how, you know, just what's coming off the top of my head that will be beneficial for people that look like me and in situations like me, because everybody's not bad, everybody's not good. Change, it's a process. I know how it is, and yeah, I just think stay more focused on like pushing through on like trying to rehabilitate, somewhere in that area, like say more personable, just the humanistic approach, just more in that area, because that's what's going to save lives, and the better good, the greater good, whatever, yeah. No,
Well,
I'm just
I-
rambling a little bit. Yeah.
But I do think, Mr. Tatum, what you have to say is very important, is you are the person who has lived through this. So you're definitely speaking on behalf of the people who are directly affected by it. And so to me, that really strikes then, if, because we definitely want to recognize what you have lived through in all of this with it. That, like that Iowa standard, for example, where even with the permanent list, there is that option for the human overview to really show rehabilitation potentially. So it's, again, we're not just looking at a permanent, again, I think potentially a smaller permanent bar than what we have, but there's still a permanent bar and still allows for a human element. Oh, you're muted.
I totally get it, and maybe I don't understand like the approach to it too much. Like I said, what they acceptance, is just yeah, it's just like you said, it is personable. So it is, I have a bias towards it, how I see things should be, and just because of my reality. But yeah, I understand, how society is being seen right now. I'm open for all of that. It's a part of that acceptance. Everybody ain't, thinking the same. We're not the same, and we're not on the same pages. But there has to be somewhere to close that gap, though. And if you don't say nothing, closed mouths don't get fed. If you don't say nothing, you sit back and just be sitting there looking stuff. You ain't gonna get nothing done.
Well, and I don't know how
I'm talking about, but my heart's in the right place.
Right. Well, and I don't know how other people feel, but I'm definitely I have to ask first to be told no. I'd rather make sure we're making recommendations of what we really want, and not maybe sacrificing some of the important pieces. I think, yes, we all have to recognize maybe not everything will get through, but you have to ask before you can get told no.
Absolutely.
And-
Madam Chair, just
And
for
that's on.
clarification.
Sorry about that.
Oh, I'm sorry.
No, go ahead, Ms. Williams. Ms. Williamson.
Just clarifying question. Could you please restate the 3 buckets?
Yeah. Well, and again, definitely open. So the first one that I feel like keeps coming up is this POE standard. And again, I'm leaving out the juvenile adjudications because I think the other group is really focusing on that. So the preponderance of the evidence standard. So of course, just to re-summarize, that would really be if we're looking at making recommendations that the statute really focuses only on convictions and does away with the POE standard. The second bucket that I think really seems to keep coming up is this permanency list. So not only the permanency list, but also if there's a non-permanent list, what is that time period? So if we're going to go away from a 15, 10, 7 to something more like what the other statute is, which is a 5. So I think that seems to be the second piece that seems to be really important and seems to keep, or at least seems to be poking its head in the research. And then the third piece would be really that appeal process. And so I think that's actually kind of a bigger bucket with a lot of pieces to it. But I think what we're really looking at is, of course, the process, the timeline. Mr. Esme was going to look at, what that actual process is and the standard, the appeal rights and the standard of review, to try to bring that all in line. So that the actual appeal process, who gets it, who gets that review, to try to clear that up.
And I would just add one other sub item to the appeals process bucket, which is the availability or lack thereof of like a non-written set aside request. I think at least I see what I hear Mr. Tatum saying is that like that ability to have some kind of personal review where you can maybe actually talk to someone might help people advocate for themselves, and I think would be important.
And I think, I know Ms. Williamson, the accountability had been very big for you. I don't want
You
to
were
ignore,
reading my mind.
I don't want to ignore that. I think to me, that definitely works its way into the appeal process because that's the underpinning of how it actually works. So I know that that was important. And hopefully I think you're probably getting some data on some of that too, which could help inform this. And so I do think, I forget if it was Mr. Esme who brought up the question of some of the data, and I forget exactly what you had said, Mr. Esme, but about understanding from the data with the change in policy, did that actually reduce the number of do we see a change in the disqualification? So, and I apologize, there are two hands and I don't know who raised their hand first.
I just really quickly wanted to say I concur with that accountability piece being a part of the appeals bucket. So thank you so much, Madam Chair.
Yes. Mr. Tatum, I'll just call on you first. You show up first on my screen.
All right, thank you. Yeah, I wanted to ask about like, okay, so they changed certain crimes and made them permanent, certain ones recently, like mine for sure. So I was wondering about, are we going to take an approach to try to get that pushed back? That's what, I'm like, because I might not be hearing this correctly. Like, might mean, like I said, I may not be comprehending everything, like what's going on, like with the remedy bucket and the 3 that's in there. And I heard what he said, like, that's I'm pretty much fit into the personable, as far as where I was going with it. But I was really just focused on that. I'm like,
and I could probably answer it really quick. Yes, that is what I think we are definitely talking about, is what should actually be on the list, what crimes actually makes, because I think we can all agree homicide is really not a good thing and that should be on the list. But yeah, so really actually narrowing down that list, as well as narrowing down what is actually a permanent disqualifier. And then should those timelines, if it's not a permanent disqualifier, should we make recommendations that be changed? So yes, I think what we are talking about would directly impact with what you have gone through.
There's like there might be we might have biases against certain crimes. Like me being in prison, I've been to prison before, so prison standards are totally like different than what people might see. Well, way different. What people see in society, like, might judge somebody for a sexual crime or something like that. You got a sexual crime, you'll be considered as an outcast or like stigmatized or something like that. And the reason why I'm making this point though is I know some murderers that will be great counselors. A society might not accept them like that right now, but I know a couple that were already counselors before they started making these, before we had to go to college and all that, and already counselors that was murderers. It's kind of different, how you see it now, because at first I'm like, yeah, maybe, but things happen to people, bad situations, and I understand it, but like society might not be ready to, handle that yet. Like you said, like what they will be willing to accept. I just wanted to add that piece though, because that is a valuable piece.
I would definitely agree. And I think that could be part of looking at then the personal element of, even if somebody does have one of those crimes, is there
what about accidental murder? Somebody just jumped out in the street and not even paying attention. You just killed him because he killed himself. Just because of an accident happened like that. I'm not drunk. I'm not high. I'm not doing nothing, but I killed this guy. I'm already, punishing myself the rest of my life. I can't do something to try to give something back just because of this freak accident happened. Would that happen? Or is the murder, would that be considered as like in the murder too?
I don't know. I don't think all of I don't remember if the manslaughters are on there. So that's something we definitely would have to look at. for sure.
Yeah, this is kind of off topic. I just had that thought about that, though. I just wanted to say, yeah.
Manslaughter is a permanent DQ.
Is it? Okay.
If I could I, is this an okay
Yeah.
time for me to
Yep,
jump in?
no,
Because I kind of want to
your turn.
respond to Mr. Tatum. So remember when we're talking about permanency, it gets a little bit confusing because there's a list of crimes for which the duration of the disqualification is unlimited. So the disqualification, in time is permanent. That just means that it doesn't time out automatically. But that is different than whether someone is barred from getting a set aside. And so that was the word that the DHS people kept using in some of their meetings, was there's a bar here. And that bar has not always existed. That's the change that came in like the mid-aughts. And what I think we should be focusing on for our first report, just to make it, doable, set a goal we can actually obtain, is to go through for each of these buckets and identify the ways that we think that the statute is not working, is failing. So for that permanency bucket, I think that's what we're saying here, is that, look, there are people who are deserving of being able to have an opportunity to work, who can effectively work, who would safely work, for whom the employers desperately want them to be here, and for whom even DHS may say, if we had the discretion, sure, we'd let them work. In some cases, like I think yours, Mr. Tatum, they had said that at one point. And then what happened is the statute doesn't currently give them the discretion to do that. And so that's a way where we can really clearly explain, look, this is how the statute isn't working with respect to that permanency list. I think we should be able to do that with the preponderance of the evidence standard as well, by looking at how other states do it.
Mhm.
And I think, with a lot of the sort of subparts of the appeals process as well, I think we can kind of go through and kind of catalog, this is what we see as a problem, and kind of explain why, maybe even be able to give some anecdotes from the public feedback. And that's how, at least I would suggest that we try to proceed here in the next few meetings we have before that report is due.
Yeah. And it's just,
No, go ahead, Mr. Tatum.
to that. Yeah, it's just kind of like what you said in my situation. It kind of, it's kind of unbelievable. Kind of. That's why it's kind of funny, because when they actually approved me, I shouldn't have got approved. I'm like, I'm not doing it. I want to do something better, but my mind ain't there right now. But I wanted to figure out, walk the steps and go that way, but I wasn't ready yet when they, and I'm now, and I'm like, wow. So it's kind of like, you know what I mean?
Right. And now their answer is we can't even look at it.
Yeah.
Yeah.
It's crazy.
Yeah. So we're at 12 o'clock right now. I guess I'm not sure how people feel if we kind of just make a plan for our next meeting and then we can adjourn. So my thought would be for the next meeting, Mr. Vogel, if you don't mind, I think the biggest piece that at least seems to have come up, of course, would be sort of looking at the Adam Walsh to see really if there's any way you can even break it down on just a PowerPoint with bullet points so that we're really simple. And I'm not asking you to go through the whole piece, but really what are their specific, I want to focus more on the crimes that they're specifically talking about and their time periods. And then, if it's even the next meeting. So if once you do that, then we can really, even if it's one of us just sharing our screen with a Word document to try to really kind of narrow this down and really identify so that we can potentially even be voting next time on, again, maybe not the actual language, but at least we have a narrowed concept and a concrete offer, if you will, for what we'd like to see recommended. How do people feel about that? Yep, go ahead, Mr. Tatum.
Yeah, and just by elaborating on that, if it had to be some kind of like the language you were saying, like if it had to be somebody that could give like an example or something like that, I would be willing to give an example, and to try to make somebody not to convince, but to come to a point where maybe you might be ambivalent or something. Maybe I might rock this way, because looking at a straight, because you never know. Everybody that tells you when they're trying to get something from you, they're gonna tell you their best qualities. They're all I'm this and that. But just to be honest with it a little piece and keep out of there all the stuff I done did and all this, and just to basically like, yes, I just don't commit crimes no more. Yes, I am the same person. I just am not gonna break any laws. That's just not the part of me. Yeah, I changed. No, I didn't change everything. I just changed the things that I did and the things that I'm going to put in my life, and actually kind of see that instead of always staying focused on that, to try to drift it a little bit, and so they could see like maybe, okay, because everybody's so focused on the change piece to it, and instead of just like, okay, so I just learned to adapt to this and kind of make it a little different, instead of just, switch it up a little bit. I don't know what you guys get what I'm saying though, like the kind of message a little bit.
That's where I think it would be helpful if even there was some sort of screen sharing where, we can literally be crossing things out and writing things that we're all, I think that potentially, maybe it won't, but, maybe that can help us to really we're all on the same page and we're all really coming to that consensus. So I think that could be helpful and then productive too.
It definitely will be. I swear it will be. Somebody talk to me like that and like, nah, I did this and all this. And hey, man, I just don't do this anymore. And just leave it at that instead of blowing a lot of smoke, and it'll change the process of when you're talking with people, even in interviews, when somebody shares, like, yeah, I did this, like, yeah, and people trust you a lot more. Even if they don't even want to hire you, they start thinking about hiring you, man, this guy's honest. Like, hey, this, and it kind of drifts people a little bit. Maybe they won't change their thoughts right then, but it opens their mind a little bit though,
Right. That makes sense. So if there's nothing else for today, we can adjourn. Thank you everybody for being here. Ms. Kissane, thank you so much for being here and just sitting through. We really appreciate at least your presence. And so thank you very much.
You're very welcome. I'm happy to be here.
Perfect. And I don't know if you'll be here. We do have our next meeting. Don't remember.
Oh, Madam Chair, actually, we have it scheduled for Monday, the 21st. That is, however, President's Day, which is a executive branch holiday. So I don't know if you'd want to.
I think that we talked about trying to reschedule that.
Yes, Madam Chair. There was that whole thing where I thought our staff would be legislative staff would be unavailable too. It looks like Tuesday was working for everybody. Tuesday at 11. Please speak up right now, like members, if that's not the case. But I don't know if you want to reschedule to accommodate Ms. Kissane's presence.
I would be happy to reschedule to the 22nd at 11. If anybody, I'm glad I actually double checked on that. So if anybody has any issues, otherwise we can do the 22nd at 11. Hearing no problems. All right, perfect.
Yeah, I'm the supervisor now. I'll make the schedule. So,
that's nice.
That happened.
Perfect. Well, we will see everybody back here then on the 22nd. And of course, Mr. Vogel, if you need something from me or anybody else for your portion you're doing, just let us know.
Thank you, Madam Chair. I will.
All right. Thanks, everybody. Have a good day.